This is Michael Popok, Legal AF After Dark, the dark and stormy night edition. Speaking of dark and stormy nights, Donald Trump is in for a possible going out of business sale as the New York Attorney General asked the court and the judge in advance of next week's closing argument in the New York civil fraud case. Went on for 11 weeks. We're now up to closing argument, but there's briefing and requests sent to the judge already. And included in that is a $370 million request by the New York Attorney General as a fine, a punishment, disgorgement, a finding against Donald Trump, and banning Donald Trump from ever conducting a real estate business or transacting real estate or obtaining loans from a New York chartered bank ever again. Want to know more? Tune into this past episode of the Legal AF podcast only on the MeidasTouch network. And here's a clip.
We've also been talking about for a very long time the New York Attorney General's first civil investigation into Donald Trump, the Trump Organization, and his adult kids, Don Jr., Eric and Alan Weisselberg and others there. Fraud. It started off as an investigation, and then in September of 2022, there was an actual case brought under New York's Attorney General enforcement statute against the Trump Organization, against Trump's adult kids. Ivanka was the only one to get the case dismissed against her on statute of limitations ground. The case remained against all of the other defendants. It proceeded to an 11-week trial. Total of 44 days. Donald Trump would show up for a few of those days, kind of rant and rave. Donald Trump showed up for cross-exam, but his lawyers never even did a direct exam of their own client. Donald Trump didn't have a choice. He had to show up for cross-exam because he was subpoenaed. But when given the opportunity for direct examination to tell his side of the story, Donald Trump did not show up for that despite saying he was going to. And he's the purported leader of the Trump organizations. Same thing with Eric Trump, who was running the organization during the relevant time period. Eric did not show up for direct examination, and his lawyers never conducted a direct examination of Eric. So when your key witnesses don't testify under direct examination and a trial is about the weight of evidence, I just want to make that very basic point from the outset. Parties who want to prove that they are not liable in a civil fraud case where they are the controlling officer of a company and they believe they have the explanation to convince a trier of fact, or to the extent that Donald Trump feels that he's not getting a fair shot before Justice Engoron, which he's getting a fair shot, but to the extent Donald Trump says that's the reason he doesn't want to testify, you at least want to create a factual record for the appellate division and eventually New York's highest court. So you'd want to testify regardless, but Trump was too scared to testify. Eric was too scared to testify. And the weight, overwhelming evidence shows that Donald Trump engaged and the Trump Organization engaged in this persistent and systematic fraud. The New York Attorney General's office filed their closing briefs at the end of last week. Trump filed his closing brief at the end of last week. And the New York Attorney General is asking for $370 million here. That kind of threw Donald Trump. It's as if Donald Trump, learned about that number for the first time. Like we all knew a number like that was coming, but the way he responded to it, just kind of constant posting about New York Attorney General Letitia James. It was like post. The day before, he posted like 80 times about E. Jean Carroll, who he was found liable for sexually assaulting and raping, because that trial scheduled for January. So that cycled into Donald Trump's mind. So he tormented his victim by posting 80 times on his social media platform. I'm not making that number up. It's like 50 to 80 times. And similarly, New York Attorney General Letitia James, Donald Trump would post. I guess he thinks that that's how you're supposed to respond to things. I mean, it's just so humiliating to our country and our legal system. But the $370 million number is actually less than I thought it was going to be. I thought it would be about $500 million to $1 billion. And there's really three buckets of damages that New York Attorney General Letitia James focused on. And I think she didn't focus on other buckets that would have had that number add up to $1 billion to $2 billion, because she wanted it to be appeal proof. And she knew that there was some merit to the statute of limitations argument, not a lot, but regarding some of the claims, there was a statute of limitations and she didn't want to be reversed. So I think she focused on the buckets clearly within the statute of limitations. That's why it was under 500 million. She made a very conservative approach there. What'd you make of the number? What'd you make of her argument? What'd you make of Trump's response, Popok?
I'll start with the last thing first. She used the scalpel to make it more bulletproof in many ways, including lowering the number. You and I were adding up what we thought was, this is all about disgorgement, which is different than damage. Disgorgement is what you can do, especially if you're the New York Attorney General under the special statute, Executive Law 63-12, to take away, rip away, claw back somebody's ill-gotten gains. That's exactly what it sounds like. Money that you were not entitled to have obtained in the operation of your business, profit that you shouldn't have gotten, the delta between what the amount of the interest rate that you should have been charged for the financial condition that you were in versus what you were charged because you lied about your financial condition. You said you had more money, more assets, more liquidity than you actually had. And there's a delta there. There's a differential there between the 1 point, 2 point, 3 point different mortgage rate that you would have gotten or entitled to, or the cash reserve that you would have had to put up or not put up, or the personal guarantee that you would have or would not have had to put up if you had been honest and truthful about the state of your financial affairs. Donald Trump was always some sort of billionaire. He just wasn't a triple or quadruple billionaire. And that difference means he got loans he shouldn't have gotten at the rates that he shouldn't have gotten them. He did deals that he shouldn't have gotten and profited on the sale of those deals. And so the first thing that she did was lower the number. You and I were like doing the back of the envelope during the 11-week trial. And you and I, we said it, we could probably find the clip. We said, this could be 500 to 750 million. Forget about the $250 million headline for when she filed the thing a year and a half ago, the Letitia James. This could be 3 times that. You and I, and it could have been if she hadn't wanted to use a surgical, like a scalpel, to get it down to, based on the evidence that was presented in 11 weeks, the 40 witnesses, including many with the last name Trump, and the thousands of exhibits and pages of documents. This is what she believes. She's got, 3 or 4 pieces of evidence and confessions and concessions by Donald Trump and those around him, like the money men, McConney, the controller, the disgraced CFO who went to jail, Alan Weisselberg, and other people that worked in the finance department, and then tangentially Michael Cohen. Michael Cohen, I know we talked a lot about the impact of his testimony, but he wasn't mentioned that much in these kind of closing requests to the judge to make findings of fact and conclusions of law. She also, though, dialed back the remedies besides money. And I did a hot take on this one too today. She originally asked for, if you go back to the petition and the original summary judgment motion that the judge ruled upon, it seems like a lifetime ago, but it was in October. Because just to remind everybody, or for those just joining this issue for the first time, Judge Engoron has already found fraud twice in this case. He did it on a standard of more likely than not that persistent fraud was being engaged in by Donald Trump, and he installed a monitor, a person who used to be a federal judge, Barbara Jones, to look at to just watchful eye over the business operations and assets of everything Donald Trump. And she's been there to this moment and makes reports as an officer of the court to the judge. That was at the inception of the case. Because if your entity in New York, regardless of who owns it, is committing persistent fraud, you can't let it operate without having some sort of supervision. So you either shut it down, which is what attorney generals do, or the CFTC or these other federal agencies when they run into fraudulent companies, or you say you can operate, but it's going to be under the watchful eye of the judge, in this case, the federal monitor. And then right before the trial, in October, the Judge Engoron ruled on summary judgment, basically almost the entire case. He ruled that count 1 was proven on a finding of no material issues of fact in dispute. It was undisputed, and that as a matter of law, he found that Donald Trump had operated a persistently fraudulent company for a decade, for like 10 years, and was ready to throw the book at him. And even said to the lawyers on both sides, like the New York Attorney General, why do we need a trial? I'm ready to rule and give the remedies. And they said, well, you got to see all the evidence, Judge. Again, back to your point, Ben, having a properly developed record that would be unassailable on appeal, 2 levels of appeal, up to the Court of Appeals, the highest court in New York. She originally asked in her complaint to have the entities dissolved, all the Trump organization entities dissolved, have their assets liquidated, replace the trustee over the Donald Trump revocable trust that sits over all of his assets, ban and bar for either lifetime or for a period of time all of the executives of the Trump organization, like Donald Trump, Weill and Weisselberg, Eric and Don Jr., and other things. And the judge was like ready to dissolve the companies. We did an entire podcast and hot takes on he's about to dissolve the Trump organization and put Barbara Jones, the former federal judge, in charge of everything. They all agreed to stay that while an appeal went on. However, now that she's made her final ask in the form of, and just to get a breakout session of Legal AF Law School here, next week is going to be oral argument, the closing argument in the case, done orally. But the judge has been making rulings all along. 3 weeks ago, he already told Chris Kise all that he needs to hear for Trump's side, that your valuation arguments are full of you-know-what, that a lie is a lie, regardless of whether you pick creatively from various ways to value your property. And it's at best a misstatement, and at worst a fraud, and tore apart all of the experts, quote unquote, so-called experts of Donald Trump, said they weren't worth the dollars they were paid. None of them were trustworthy. I'm not relying on any of them. I already found fraud in this case, and you act like I didn't. And that's your major problem, and you've been on the wrong foot ever since. So this is the judge that's now primed to listen to closing arguments. We know Chris Kise's closing arguments, and we know what Letitia James is now, because the judge has requested, as all judges do in cases like this, that the parties submit competing findings of fact, proposed findings of fact, and conclusions of law. Because when a judge sits as the trier of fact without a jury, he or she both determines the facts based on the evidence adduced at trial and makes the law conclusions, the judgment. And so they both submitted those. Of course, Chris Kise, on behalf of Trump, says there's nothing to see here. There was never fraud. There is no fraud. The assets are fine. Nobody was misled. Nothing was overvalued. There was no cooking of the books. And there's overreaching by the New York Attorney General, untethered to reality, untethered to any evidence basis, and the whole thing should go bye-bye. He's tried that 5 times in the case, as the judge noted when he ruled in the middle of December and denied his 5th attempt to have the case dismissed at the close of evidence. On the other hand, we saw 100 pages of the New York Attorney General clearly laying out, we'll hear it in the closing argument, laying out the case of fraud, and her picking 4 different pieces of real estate that Donald Trump profited illegally from because he cooked the books about a statement of financial condition, a financial statement that was relied upon by counterparties, insurance companies, banks, lenders, buyers, sellers, and you name it. And she hit him right where she lived, on ones that, based on the evidence, she believes that is unassailable, that he made hundreds of millions of dollars on the old post office down in Washington that was used for a Trump hotel, both in the buy, the loan, and in the sale. And that's part of the money that should be clawed back from Donald Trump and everybody related to him. Things related to Mar-a-Lago, related to 40 Wall Street, related to some other properties. You total it all up, and clawing back the bonuses that were paid to Alan Weisselberg and McConney, and that all totals that almost $370 million. But then when it came to the other remedies, she dialed that back a bit too. She still wants Donald Trump banned for life. Listen to this one. Banned for life from ever conducting a real estate business in New York, including taking out loans from any banks that are chartered in New York, which is all the major banks, and conducting any real estate transactions at all of any kind in New York, forever lifetime ban, which means his being that sexy real estate mogul that he's talked so much about and bragged so much about, that myth is gone forever. He took his father's real estate empire and flushed it down the toilet of fraud, according to Letitia James. So that happens. The kids, Eric and Don Jr., she wants them banned for 5 years from doing anything. All of them she wants banned from ever operating any business related to anything in the state of New York, either lifetime or 5 years, depending upon who it is. Trump, of course, lifetime. She's gotten away from the trust issue, which is fine. And she hasn't asked for the dissolution of the companies, but she wants almost a permanent financial monitor placed over these companies for like almost indefinitely. That's what permanent means.
Well, Popok, the company's already dissolved. The summary judgment order is the dissolution of the company.
No,
so,
that was stayed. That was stayed pending the appeal.
Right, but there's already an order saying that the company. I get that it stayed, but
she's
there's
not
an
asking
order
for that now. That's my point. She's not asking that in her final ask.
She doesn't have to ask for it because it was already granted by the judge. So the judge already granted dissolution.
Yeah. You and I
that appeal is stayed. What did you say?
You and I disagree on that. I think
no, there's nothing to disagree with. Give me your point. We'll debate it.
Yeah. Well, let me finish the point. So the point is on remedy. She's asking for her final remedy. And I don't believe that this ask is inclusive of what has been stayed pending the appeal. I think she is asking finally for this and not asking for the trust replacement, the trustee replacement, or the dissolution. Instead, she wants a permanent monitor for the continued operation of the company as long as the company does not engage in real estate transactions or real estate loans in the state of New York. They can do whatever they want other than that. They want to go Trump University, which already got disbanded, or they want to sell stakes or whatever they want to do, but they can't do real estate in New York. See, I think she's backed away from that completely. And I think when we see the final decision or judgment by the judge, he's going to kind of clear that up. He was on a little bit shaky ground with the dissolution of the company aspect of it. And I think they are all kind of backing away from the precipice. You could be right, but that's my read of her new requests.
Yeah, no, I respectfully disagree with what you're saying there, because the summary judgment order already granted the dissolution. There's an appeal process that's already taking place regarding that. That appeal process is what New York Attorney General Letitia James has already stipulated to staying that appeal until the remainder of the issues in the trial are resolved. So there's already an appeal process on the dissolution, which
we don't agree on this. We're going to find out. I'm going to find out. I'm going to put my New York bar license on this one.
I'm willing to, but there's an order with the Supreme Court. There's an order with the appellate division staying that so that the rest of the issues. I agree that this is exclusive, not inclusive of the other decision, but it doesn't need to be inclusive because the other thing is not part of this trial. That's already been decided. That's going to go to the appellate division anyway. And now what the appellate division was waiting for, why New York Attorney General Letitia James why she was agreeing to stay the enforcement of Judge Engoron's dissolution order that predates the trial, is she agreed that eventually they're going to have to be unified. The dissolution order, which already exists and was already found, plus all of these other causes of action that were now before the court. The dissolution's no longer before the court. That's why New York Attorney General Letitia James doesn't need to address it in her closing brief. The only issues now, because dissolution has already been determined, are the injunction to ban Donald Trump for life, which she's requesting, to ban Eric and Don Jr. for 5 years. She's requesting the continued monitor and disgorgement of $370 million on top of what has already been decided.
But not the trustee. She's dropped that as well. She's not asking for a trustee.
Which part about it?
The trustee replacement. She's not asking for trustee replacement.
And she's asking for the continued monitorship by someone like a Barbara Jones for at least a 5-year period after, to ensure that the steps are taken to fulfill any final order, because New York Attorney General Letitia James argues there's been consistent ongoing fraud even while this case has been taking place. Right,
but that's why I take the position that the financial monitor for 5 years is the replacement for the dissolution, because dissolution would happen overnight.
No, I disagree. I think that the financial monitor would both oversee a dissolution. You can't dissolve anything overnight. I mean, in theory, it's still going to take time to have to sell the assets and do something with the assets. So that literally couldn't take place.
We're going to know at the oral argument and beyond, and the judgment.
Right. We will go back, pause that. The one argument, though, I do want to make that I think we can both certainly agree on here, though, is on the issue of valuation. Donald Trump's argument about subjective valuations. And that was one of Donald Trump's main argument in his closing brief. Valuations are all subjective. So if Donald Trump and his people give a valuation of hundreds of millions of dollars, you can have come up with a different valuation. And that's just such a red herring argument. And Justice Engoron has addressed that time and time again. The Justice Engoron acknowledges, I acknowledge, Popok, you acknowledge that valuations can be subjective. You can't just make up ones that don't exist, but there are different methodologies. The issue here is not subjective valuations. It is the input into the valuation methodology. And when you characterize a property as a residential property to inflate the value, when on paper it's a commercial property that has all of these, encumbrances on it, and you've devalued the property to pay less property taxes, but then you put a fraudulent input into a valuation methodology. That's the issue with this case. Mar-a-Lago is a commercial property. Donald Trump is engaged in fraud, saying that it's a residential property and therefore valued at far more. Donald Trump says that his buildings are fully occupied at the highest possible lease rate per square footage, when in fact they're rent controlled and not fully booked. You can go through all of the examples like that, and that becomes, Donald Trump says the penthouse is 30,000 square feet. It's 10,000 square feet. So it's those differences that form the fraud. And then when you put them into any valuation methodology, it is inherently going to be fraudulent.
Can I read you one thing? You're exactly on point. We just got a ruling from the judge exactly saying that on the 18th of December. Here's what he said. This is the same judge that's hearing the oral argument in denying the fifth attempt to dismiss this case, just on the 18th of December. That defendants also, the Trumps, trot out two of their standard lies, two of their standard canards about valuation. He says that valuations, as elucidated ad nauseum in this trial, can be based on different criteria, analyzed in different ways, but a lie is still a lie. And then he goes over valuing occupied residences as if vacant, valuing restricted land as if unrestricted, valuing an apartment as if it were triple its actual size, valuing property many times the amount of concealed appraisals, valuing planned buildings as if they were completed and ready to rent, valuing golf courses with brand premium while claiming not to, and valuing restricted funds as cash are not subject to differences of opinion. They are misstatements at best and fraud at worst. That is the headwinds that Donald Trump is going to be heading into with his lawyers for the closing argument 3 weeks later with the same person. They're going to lose. The good news is I can report with confidence, despite our prior conflict, he's going to lose later this month. And then he'll take an appeal to the First Department of the Appellate Division in New York. He'll lose there again, and he'll take it to the Court of Appeals, and that will be the last step. There's no Supreme Court that's going to bail him out. There's no way to jump over to the federal tracks and do something else. And so, this amount I think will be confirmed. I thought it could be higher. And the judge, by the way, this is a recommended number. The judge is keeping track. That's one of the things this principal law clerk is really doing, is keeping track of things like the deltas in valuation. And the judge, I've had judges take my proposed findings of fact and conclusions of law and rewrite them and revise them. So I think the floor is $370 million. This judge could go up higher if he feels the evidence supports it in his final rulings.
We will see what Justice Engoron does, and we will see in the debate that you just saw live here what the ultimate remedy is going to be.
Well, if you like lawyers talking about things, they know what they're talking about at the intersection of law, politics, and justice, you've come to the only right place. That's the MeidasTouch Legal AF podcast. We do it just like that, times 5, twice a week. Wednesdays and Saturdays, 8 p.m. Eastern time on this YouTube channel. You knew that. And on audio podcast platforms of your choice. If you know all about Legal AF, take that clip, send it on to a friend or somebody in your life that you'd like to introduce to the show. It's a great way to get them involved and have them join our journey as part of theirs. If you have no idea what I'm talking about, I'm Michael Popok. That was Legal AF, and we welcome you to join us for our next episode. So until my next hot take, until my next Legal AF, this is Michael Popok reporting.
Thanks so much for watching. We're only a few subscribers short of 2 million subs. Please subscribe right now to the MeidasTouch YouTube channel for free and help us grow this unapologetically pro-democracy network.